Okay, everyone, this is my recap and review for day 2 Supreme Court confirmation hearing for Judge Katanji Brown Jackson. This was a long day. They didn't even finish. They had to do, I think, 2 senators. They had to, carry on into the next day. Hopefully, I'll be able to get through day 2 all in one video, or what would have been day 2. Day 2 was supposed to be the 30-minute rounds with each senator on the Judiciary Committee. And like I said, they had to do 2 of those 30-minute rounds on day 3. But we'll see how far we get. If I have to split it up, we'll see what happens. Um, I do want to start out with let me just get into it. So Dick Durbin opens. He Democrat, Illinois. He's the chair. He just kind of reminds all the senators to be as clear and concise as possible. Again, it turns into a long day, and they had a few breaks where they had to go vote. They had their lunch break, and then just kind of courtesy 10-minute breaks here and there. Um, let's see. He begins his questioning. And I think I mentioned in day 1 there was an issue about getting the Sentencing Commission's transcripts, but then in Dick Durbin's, as he starts the hearing off, he mentions stuff that he read through the transcript. So I guess they did get the Sentencing Commission transcripts. Good for them. Whatever they got, I'm sure it's sufficient. Probably not that big a deal. He goes into saying that Katanji Brown Jackson is going to be asked about her judicial philosophy. She's written well over 500 written opinions. Um, he asked her, what is your judicial philosophy? She says that she doesn't have a judicial philosophy. She has a methodology, or a method that she follows when she gets a case. So she says she starts from a position of neutrality. She kind of tries to clear her mind from all, prejudgments or preconceived notions. She gets her information, input, the brief, the hearing, the factual record, whatever comes in. And then she does an interpretation, application of what laws would apply in this situation. She says that she observes judicial constraints. Um, you know, Judges have limited power, or they're supposed to have limited power, things they can do. She says her she adheres to whatever law is supposed to, or statute is supposed to apply. She looks at the text and what those words were meant to mean by the drafters, historical practices, um, congressional purposes, uh, precedent that might be a constraining factor. And initially, and we'll get into it, she'll go over it several more times about how she looks at the text and she wants to know what was the plain meaning to the public at the time the rule was written. And, that sounds like a nod to definitely originalism. To me, this is my recap and review, so I throw my opinion in here. To me, that's not necessarily originalism. Of course, you would go back always, whether it's the Constitution, whether it is a statute from the 1990s, a statute from yesterday. Of course, you have to examine what the plain meaning of these words were to society at the time, what the drafters kind of probably understood as the point, or as the spirit or intent that they were making at the time. That to me is legislative intent and legislative insight. But I guess, because if you're talking about the Constitution, which usually the Supreme Court is checking something up against the Constitution, you're talking about our country's original founding, but plain as it is, how she describes her judicial methodology is closer on the scale to originalism than not. So, Dick Durbin says he's going to go ahead and ask her about court packing because she's going to be asked about it a lot. He takes a shot at Mitch McConnell for keeping the court at 8 justices for a year. We know that was Merrick Garland's stalled hearing or confirmation hearing when Scalia passed. I think it was when Scalia passed. And then he mentions that Amy Comey, is it Coney or Comey? I think it's Amy Comey Barrett, said that she wouldn't opine for that. That's a merit of public policy. And Judge Katanji Brown says she's going to take that same approach. He goes ahead and wants her and, asks her about the child. I don't know the rules of what we can say for informative purposes. They ask her about the cases of images of children that are not what they're supposed to be. I don't know the rules on this platform of things you can say and things you can't say, but hopefully child cornflakes. Hopefully you guys get what I mean by that. He go ahead and preempts the conversation because, Josh Hawley's gonna mention it. And, she discusses that, she takes these cases very seriously. She listens to the victim impact statements. I don't know if I mentioned the story in day one that she told, but she takes these cases home. These are very horrendous crimes. She understands that. But she says it's, goes more into that. And I don't think I wrote down that she went in depth in that here, but we'll get to it. And again, I'll just start off with, I don't think it's unfair of them to breach the subject. They need to ask her about that. To me, if we're talking about being equal or equity, I think I'm using that word right, then if we're going to be harsh on everybody, then it should apply to everybody. If we're going to be soft on everyone, then it should be soft on everyone. So I feel like her predecessors got pressed for whatever record they had. Most of them came from academia. She comes from practice. So it's a little bit different. But Amy Coney Barrett got very much pressed on her views of abortion, which that gives you insight into to how they think about things or how they might judge cases. They're not going to give you a forecast, but it's a clue. I can't go so far as to say they're wrong to breach the subject about, her downward trend from the sentencing guidelines. But to me, we'll get into it later, but she explains herself. And once she gives the explanation, it makes sense to me, but we'll get to where she goes in a little bit more detail. Okay. Actually, this is where she does. So Dick Durbin then points out that all of the cases that they're going to bring up resulted in incarceration in some way for some extent of time. And then Judge Katanji Brown explains, and she makes this explanation several times. And to be honest, at first, when they brought the subject of the child cornflakes and the sentencing up, at first, I was like, I don't like it. I don't like it. Everybody has a visceral response to things. I'm willing to hear an explanation. I'm willing for you to put those facts, because they're facts. I'm willing for you to put the facts in context, but I didn't like it. And she explains that these sentencing guidelines, particularly for these types of cases, these were brought about in the 1980s, or they were a long time ago. This happened long time ago. At that time, the images were delivered in the mail, most primarily in the mail. So when they did the sentencing guidelines, if you had large volumes of these things that were mailed out, that was a accelerating factor. I think that's the word. I'm not a criminal attorney. I try. Accelerating factor. Or if you were using a computer at that time, mind you, this is before wide internet accessibility. So back then, if you were using the internet, that was an accelerating factor because you were trying real hard. She says nowadays, it's all on the internet. Everything she sees is on the internet. So you might click on something, and in 15 minutes, that person has tens of thousands of images. And so when you look at it that way, if she were to follow the sentencing guidelines as they were understood at the time, that 15 minutes, 10,000 computer images is 15, 20, 30 years. And that's not really proportionate with the situation we're dealing with in today's world where internet is the primary modality. Again, we don't have to like it, but some things do make sense. And that made sense. If everybody that clicks on something and gets 1,000 images ends up in prison for 15 years, when we start running out of room and then people aren't in jail who should be because we ran out of room, don't look back. And they'll go on later to say, and I'm probably not going to talk about it later because this is going to get long, but later she'll get questioned about this and she'll discuss that these used to be mandatory sentencing, and then at a Supreme Court case where the opinion was written by Scalia, the Supreme Court made these discretionary, and the judges have discretion. And then she'll also explain, and other senators will also bring up again that this downward trend in the sentencing for these cases, that's a nationwide thing. It keeps happening because, back when these were written and you're sending things in the mail, yeah, it was a big difference between being caught with one thing, two things, and tens of thousands of things that you're sending in the mail. When she gave the explanation, I didn't have to like it. It's not pretty, but it made sense to me. But, I'm not the one that has to confirm her. Made sense. What else does he talk about? Dick Durbin goes ahead and asks her about the representation of Gitmo detainees. And again, they both, Dick Durbin and Katanji Brown Jackson, in her response, they both reiterate that this is a Sixth Amendment right to counsel that is in our Constitution. Since everybody wants to be so originalist and everybody wants to follow the Constitution exactly as it is, that's in the Constitution. I put that little sauce on it myself. She didn't say all that. She was very polite. She has a brother who's in the service. I think that's the brother that they keep showing that was at the hearing. He is a nice looking young man. I appreciated them showing him. But yeah, so they talk about that. She explains that these were habeas petitions. My understanding, without looking it up, as a good law student and lawyers should do, but from what I remember from school, my understanding of a habeas petition is that you're petitioning against your detention, that you're saying that you're being held and you shouldn't be held. I don't want to say you're being held unlawfully, but the circumstances around your detention aren't what they are purported to be. That's a habeas petition. Somebody fact check me if it's late at night. Um, what else did they go into? So then Chuck Grassley, the Republican from Iowa, talks. He asked about fundamental rights to protest, cameras in the Supreme Court hearings. I know recently a lot of conservatives and Republicans have been talking about the cameras in the Supreme Court hearings. And I'm just going to tell you, I don't think that's a good idea. And the reason I don't think it's a good idea is because all I could think of is Ted Cruz, who yells all the time. He's always screaming. And later on, somebody's going to say something about those cameras. We'll see if we get to it, but I do feel like that people act the fool in front of the cameras, and he's one of them. Ted Cruz is. I don't think that's a good idea. He didn't used to do all that screaming. Now, maybe back then, maybe I used to agree with him a lot more, and maybe I didn't notice it, but I don't feel like he used to do all that hollering. Get off my soapbox. That's what's going to take this so long, so I keep getting off topic. So let's see, he talks about I don't know. This one he just she mentions, I don't know what the exact question was, but she's the first Floridian to be nominated to the Supreme Court. I thought that was kind of cool. Her parents attended segregated school and she didn't. And she talks about how, in one generation, the world had changed. Grassley asked about court packing. And, she doesn't answer. And then he says that when she was confirmed in 2013, I want to say to district court. I want to say she was confirmed 13 to district court and then 2021 to appellate court maybe. But anyways, when she was confirmed 2013, she said she didn't really believe the Constitution was a living document. And then in 2021, she didn't answer. And he said, what changed? And she said, in 2013, I wasn't a currently sitting judge. In 2021, she was a sitting judge at the time. And she feels that, there's a certain way you conduct yourself then as a sitting judge. You don't give out all of that. I agree. And I think I remember Amy Coney Barrett saying similar. The reason I keep bringing up the things that Amy Coney Barrett says is because just like, I don't like the hypocrisy. When it's your side, if it was okay then, when it's the other side, it's okay too. And that's okay. That's how we have to live. It's just, you have to stand up for something. And I think they're all qualified. They all have about the same qualifications. They're going to get on the court whether, you really like it or not. They're all fine. It's not that dire. It's not. I don't know a case that just turns on one judge. One judge is going to there's 9 of them. There has to be a majority. There has to be some type of giving. There's 9 of them. So, I just don't operate in a constant state of emergency all the time. They talk about the dark money. I'm sick of talking about dark money. I'm going to move on. Grassley asked about international law. Now, I can't remember quite what he said because, the gist is international law has no place in analysis of American Constitution. Well, I went on my soapbox and I took my notes. So I don't really know what Grassley had to say, but I'm going to tell you what I'm about to say. That's ridiculous. The framers, when they drafted the Constitution, they considered international law because they looked to how government, we didn't have a federal government at that time. We didn't have one. That's the whole point of why we were at the Philadelphia Convention. We were trying to create a federal government. We're not that old of a country, real young. So the framers looked to how Britain had set up their central government. They looked to France. They looked through these things. And a lot of things they said, it kind of works here, but we don't want ours to work that way. We want to be different. We want to be new. But the fact of the matter is they still considered those things. I think we need to get out of this idea that if you learn about something, that makes you that thing. So if you read about Marxism, that makes you a Marxist. No, that means that I'm trying to get more information. That information input is a good thing. I'm trying to bring in the most ideas so that when I then say that this is my position on an issue, I know that I considered the most information and I still was able to come to my conclusion. So I don't like this idea that you can't ever bring in international law. There's other reasons to bring in international law. If you have an issue that touches and concerns behavior of a treaty, we know that treaties are ratified by Congress. If the behavior is something that Congress ratified in the treaty, in that instance, that international law becomes our law. We have to act in accordance with the treaty that was ratified by Congress. When Congress ratifies a treaty, and the treaty dictates certain behavior, Congress is saying, yeah, we agree to adhere to that behavior. So if the behavior in question in the law, in the court, concerns behavior from a treaty, then yes, international law may come up in that instance. If it's a novel issue, an issue, and it's hard to believe, but this still does come up, maybe an issue that we as a country, we as a court system, we haven't taken this issue up yet. But maybe our neighbors, and typically we look to other Commonwealth nations, so we probably would look to, Canada, Great Britain, that's you, Australia, New Zealand. Those are, I think, that's usually who we look to. But if it's a novel issue, then why would you not look to see if it's been taken up in other international jurisdictions? And what have they done? And has it worked? Then you would consider information regarding international law to be brought in. What else? If it's, nowadays, everything's international commerce. The economic borders we live in terms of commerce, it's borderless with the the invention of the internet. So if it's concerning maybe an international company or maybe substantial business internationally, those things, then yeah, you would look to international law and see what is the information, what are the scholars saying about it? What's the information out there? So I don't like this idea that you just preemptively say, oh, international law doesn't have a place. Not a. Grassley asked about immigration. The Make the Road challenge is going to come up about expedited removal. She, as a district court judge, she decided this case at the appellate level. It was overturned, or maybe she decided it at the appeals court and then, or the circuit court, and then the Supreme Court overturned it. Either way, she's going to repeatedly say that this was an Administrative Procedure Act case. They're going to accuse her and say, oh, you ruled this way because you didn't like Trump. No, she gives a reason. She says, I ruled this way because it was about the procedure. It wasn't about the policy itself. It was about if the agency followed the proper procedure as dictated by the Administrative Procedures Act. One thing about administrative agencies, so how it works is Congress passes a law, and then the executive branch, which includes administrative agencies, has to promulgate, aka carry out the law. They have to execute the law. They have to put that law in practice. And they do that by different administrative agencies, different administrative rules and regulations and stuff like that. There's a thing called the Administrative Procedures Act that governs how agencies have to conduct themselves. that governs how they have to conduct themselves if they want to change a rule, yada, 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 yada. So this case didn't even get into whether we need to deport people, anything like that. This case was about if the agency properly followed the rules that they were supposed to have followed by Congress's Administrative Procedure Act. And the long and short of it is, if an administrative body doesn't follow their own rules or doesn't follow the Administrative Procedures Act rule, then the behavior gets invalidated. That's it. When the behavior gets invalidated, they have to go back to the drawing board and follow the rules. We don't even get into whether the behavior was good policy, good law, bad law. We don't even get into that. If you didn't follow your rules in getting to taking these actions, it's out. So she basically says it was Administrative Procedures Act case. She didn't even get into policy. Then Senator Leahy from Democrat from Vermont, as I said, from the day one recap and review, the Republicans are going to ask the hard questions because this isn't their pick, is the best way I can put it. If you think back to Gorsuch, Kavanaugh, Amy Coney Barrett, the Democrats asked, those tough policy, judicial philosophy questions. And mainly the Republicans, they gushed and, talked about the good stuff that she had done in her career, or the good stuff, because it was their pick. This is the same kind of way. The Republicans are going to ask those actual policy questions, the substantive questions, and the Democrats are going to gush. That's just how it works. That's why it goes Republican, Democrat, Republican, Democrat, Republican, Democrat. It doesn't bother me. It's just how it's going to be. Anyways, Leahy talks about, oh no, he did get into a little bit of substance. He's just said, they're going to play the everybody's soft on, Democrats are soft on crime. They're going to accuse her of being soft on crime. They're going to keep saying she represented terrorists and this and that, and which is true. This is exactly what they do. He points out that less than 2% of her cases were reversed on appeal. That's pretty good. I wrote down, bless his heart, some of these senators just talk so slow. That don't mean they have to scream and yell, but it has to be some type of balance in the middle. Then we get to Senator Graham. He asked her, he brings up the past treatment of Amy Coney Barrett and how they treated her about her faith, and the Kavanaugh, Janice Robert Brown, I think I'm saying her name right. She was a African-American judge that the Republicans wanted to get her up to being a Supreme Court justice, but, because I don't know, he just really kind of aired his grievances about the treatment of the past Republican nominees. I can't say it was completely unfair. I think it, in a way, you bring up things from history so you can remember not to do it again if it wasn't good. So, as someone who's fighting for more history, for all of the history, he's bringing it up so that he can remind them of how they acted. Because there were some things about the Kavanaugh hearing that were kind of shysty. It did seem like they waited to the last minute with key information. I did feel like something about that didn't sit well in my spirit. It didn't. But what I did like is he keeps bringing up Childs, who Biden did not pick. And I just feel like that's That has nothing to do with anything. She didn't get picked. She didn't get picked. Lindsay, your presidential bid ended in failure. I can't help that, sir. She didn't get picked. Anyways, let's see. After he talks about that, he talks about, he mentions that he was a defender and when he was counsel for the Air Force. So, he said you have to take whatever comes with you, whoever comes at you. He talks about enemy combatants. He goes on for a minute about, and he directed it at Judge Katanji Brown Jackson, but I don't think it was really directed at her. About basically, Lindsey Graham doesn't like the idea of having enemy combatants, terrorists in the United States judicial system, because then we do have to play by our rules, and they have an attorney, like how she was an attorney, because that is the rule we set forth. He thinks there should be another process for that, because terrorism is not crime, and we're dealing with war issues of acts of war. That's not crime. To be honest with you, I can't say I completely disagree with him on that, but that's not Katanji Brown's fault. And when she was representing clients, I'm not gonna lie, I actually don't care that she represented them in private practice or that she represented them as a public defender. When you go to court, in federal court, by our Constitution, that's what the framers put in the Constitution. The Constitution, then you are entitled counsel. You have a right to counsel, enumerated in the Constitution, plain text meaning of the Constitution. So I don't know why they kept giving her issues with that. And when it comes up, I'm not even going to talk about it from this point forward, because I don't care. That's what happens. And then he, goes on and on about Judge Childs. Grow up and out of it. Sick of hearing about her. Maybe next time, but this time she didn't get picked. She didn't get picked. Go sit down somewhere. You win presidency next time and you get to pick whatever you want to pick. That's not what happened. They go over her judicial philosophy again. He says he's trying to make sure she's not an activist judge. I will say, to me, it is all activism. All of it. If you are a conservative judge, you have a position. You have a conservative position. If you are a liberal judge, you have a liberal position. Now, you might get the same set of facts, and you might even approach the law in the same way, but you still have a position. And sometimes I feel like either side assumes that, their side is not a position. No, it's still a position. It's not a place of neutrality. There's not many people that come from a place of perfect neutrality, just themselves. To me, if there's liberal activism, there's conservative activism too. It's all activism. And I don't like acting like neither side does it. It needs to stop, period. But whatever. And then Dick Durbin. And then Dick Durbin and Lindsey Graham got into it. Because Lindsey Graham ended up walking off, but Dick Durbin took him a little praise break. And he said, well, if we move it would be cheaper to move the Gitmo detainees to regular prison. And then him and Graham started going back and forth. And Lindsey Graham got up and walked out. And Dick Durbin got the final word because Lindsey Graham got up again. I'm on a sliding scale. I'm way closer to Lindsey Graham when it comes to this situation. I do think there is a difference between when we cross over into terminology and areas of the law that you can't even get proper discovery for because they're confidential, because it's concerning national security, than crime. And I do think that the place for that maybe isn't in regular criminal court up the street. The place for that might need to be, in a military tribunal with people that deal in defense. But I thought that was funny because they went at it for a minute. Then Senator Feinstein, Democrat from California, talks. She asked about abortion. Katanji Brown Jackson says, she's going to follow the examples of others before her. She's not getting into that. And, she just kind of state that it was historic and, talks about the support letter from the Fraternal Order of Police. They're going to bring it up a lot. Didn't ask too much. She talked about meaningful gender representation on the court. I want to say she said, I think I said it last time, this is her 10th one of these. I always thought that was cool. Senator Corn, Republican from Texas, speak. He talks about stare decisis and how, even though Dred Scott and Plessy v. Ferguson were precedent, Brown v. Board of Education overruled it, so you can overrule precedent. But I will just remind everybody that every side does it. It's okay to turn down precedent when it's something that you want. So both sides do it. I just don't like acting like, let's not act like everybody is petty when they want to be. Whatever. Then he asked about Katanji Brown Jackson. She says, as a judge, she likes to stay in her lane. She explains that, and he talks about, it's important to stick to the Constitution because judges, they're not accountable to voters. I will say, as I understand checks and balances of government, I can't identify one part of government that can't check the other part of government. No. You can't remove us. It takes an act of God to unseat a Supreme Court justice. That I understand. But Congress can pass a law. The Supreme Court can say something on Monday, and Congress can pass a law on Tuesday and say the opposite. And guess what? Until it comes up in court again and Supreme Court deals with it again, that is the law. How it works is, let's say Congress can take the Supreme Court completely out if they want to. Congress can. The Constitution is amendable. Our framers didn't want it to be amendable so easily, but it is amendable. So, each branch has a check and balance. It might not be an easy check and balance, but believe me, there's a check. Courts are passive. Courts come up when someone sues. The Supreme Court Congress doesn't pass a law on Monday and the Supreme Court says, oh, we think that's unconstitutional. That's not how it works. Somebody has to challenge that law in court. When the law gets challenged, it has to make its way to the court system and whatever, the proper procedure is. And then then the Supreme Court can weigh in on it. But if nobody challenges it, everybody just lives with it, it's cool. The Supreme Court doesn't do anything. So there's always a check and balance. The problem is Congress isn't doing what they're supposed to be doing. And so I don't know what they're looking at everybody else to do their job. Do y'all's job. Pass laws. Pass legislation that's not 5,000 pages. Figure out how to do that. But I digress. Corman goes into the Obergefell case. That's the same-sex marriage case. And really, I got off of him. I didn't care. This was a long day. It didn't bother me. I will say concerning same-sex marriage, I think he said something about infringing on religious rights. And this is how I understood the Supreme Court decision in Obergefell as it relates to same-sex marriage. This is how I understand it. And I might be interpreting it a little bit different. I didn't see where they said that a pastor has to marry somebody they don't want to. Pastors don't even marry every straight person that comes in there. You might go to a church and say, oh, I want you to marry me. They might have you do marriage counseling before. They might have you do any a number of things. They might just say no. So I don't know any church that just marries even every straight person that comes in. What the decision said was the government has to recognize same-sex marriage. So the church doesn't do tax cuts for married people. The government does that. The church insurance and recognizing, you know, uh, death benefits and joint bank accounts and those types of things, that the church doesn't do that. The government or government agencies deal in that. The court said that the government, as far as it relates to same-sex marriages, the government needs to recognize those things, those governmental control things. Nobody's telling any pastor who to marry. Again, they don't even marry every straight person, and rightfully so. And rightfully so. That's just how it works. If you've been to church, they can pick who they want to marry. So I just don't know why that's such a big deal. You don't like gay marriage? Don't get in one. That's all I can say. Move on. Everything that I don't like or necessarily agree with, that doesn't mean that needs to be a law to how someone else has to live their life. You know, we live in a society. Shout out to Seinfeld. Um, what else did he go into? I don't know. I got off of him. It's a long day. Oh, the recognition of unenumerated rights, new rights. Sometimes people slip be showing. Um, I don't know. Um, he talks about the unaccountability to the voters. I already talked about that. Every branch can check another branch. There's a way to do it. And it's funny because they're hammering her about how judges are unaccountable to voters. Amy Coney Barrett was unaccountable to voters too. All of them are. Gorsuch, Kavanaugh. It wasn't a big deal then. Just stick to the issues. Stick to the issues. They talk about how in a brief that Katanji Brown Jackson was in, Bush and Rumsfeld, the Secretary of Defense at the time, were called war criminals, as alleged by the enemy combatant who was suing them. Again, y'all, it's not that deep. You sue, they had to be sued as officials. So they had to be named in the lawsuit. And of course, if you're a defendant locked up, you're going to say anything you need to say to get unlocked up. And if she's representing her client and it's a brief, she got to put that in the brief. And so she puts it in the brief. Apparently, maybe this particular case went on into the Obama years. And so that's who then became the criminals then, who, that didn't bother me. That's how it works. You advocate for your client. That's what you do. If your client is locked up, they're going to say everything to get out. They're going to say, oh, they didn't do me right. Oh, they didn't follow due process. Oh, they didn't do this. You're going to write that in. Yeah, that's how it works. Anyways, Senator Whitehouse was next, Democrat from Rhode Island. Senator Whitehouse did what I'm calling like witness rehabilitation or character rehabilitation. Just let her clear up anything from the last person, and then he gave mainly a speech. Sometimes they just talk on both sides. Sometimes they mainly just talk. They don't ask questions, but then he talked about, and he admitted, he said it's dark money on both sides. He said maybe they can get rid of it through legislation. He said it is, both sides have it, and that's just it. He talks about the dark money from the Federalist Society. The Federalist Society picks, honestly, they pick all the Republican presidents' picks for the Supreme Court are usually backed by the Federalist Society. I think Gorsuch, I know Gorsuch, Kavanaugh, and Amy Coney Barrett were all backed by the Federalist Society. I don't know if I'll go as far as to call it dark money. However, I will say this for people that don't know what the Federalist Society is. When I was in law school, I was a part of the Federalist Society. Great organization. I loved it, but you know, the student price for membership and the not student price for membership is a thing. It is. But the Federalist was a great organization, but they have a certain set of principles that they represent as an organization. So for most people, if you join an organization, typically you join one where you align to the majority, maybe not all, but the majority of the principles. So the Federalist Society believes in very limited federal government, more role on states' rights or states' options than the government telling the state what to do. You know, just a smaller federal government. I don't disagree, which is why I was a member of the Federalist Society when I was in law school. But that's a position. Not all lawyers are in the Federalist Society. That's not something that I'm not anymore. It's not something where it's like, oh, every lawyer's in the Federalist Society. No, it's a position. They're not neutral. That's fine, but that's still a position. So I don't know. Maybe it's all dark money then, all of it, just all of it. But that is a position still. If you're an attorney and you are attorney past law school, because sometimes you get in stuff in law school to network because the student prices are so cheap. It's like $10 a semester with some of these organizations. Then when you get out, it's like $400, $300 a year or whatever. But if you are in the Federalist Society as a practicing attorney who's now barred and, that is your profession, chances are that in the majority, you agree with a lot of the principles of the Federalists. That's okay. I don't think anything's wrong with that. I just don't want us to sit up and pretend that that's not a position. It's a position. But, White House just uses the chunk of his time to rebut what was said before. Let's see. And then he talks about the importance of a civil jury. So a jury of your peers in civil trials. And he uses that to give a monologue about mandatory arbitration and how it's cutting out the role of the, jurors and in important cases and things like that. So we come back from break, and then Dick Durbin felt the need to clarify the Bush-Rumsfeld war criminals things. I explained that earlier. It was a brief. Those were allegations made by somebody who was locked up and didn't want to be locked up anymore. She represented her client. She put it in the brief. You can substitute those names for anybody. Then Mike Lee, Republican from Utah, talks. What I appreciate about Lee is, to my recollection, I've never really seen him get out of pocket. Not even if he was kind of getting smart with somebody, he wasn't screaming and yelling and acting aggressive. That if nobody's yelling, why are you yelling? But usually he, for the most part, to me, it seems like he's trying to be polite. And I'm starting to think Mitt Romney is also a senator from Utah, and he tries to be as polite as possible as well. But what I remember of Mike Lee, I hope this is going to start repeating, but during Trump's second impeachment hearing, the government attorneys I guess, yeah, at that time it would have been the government's attorneys, the attorneys from Congress. They said that he said something. So at the end of the hearing, he got up and said, they said I said this and I did not say that. And it was a big old procedural kerfuffle about how to get it off the record and this and that. And, not everything is the time to do everything Robert's Rules of Order, but they're old and they don't know anything sometimes. There was nothing for anybody to do but say, he didn't say it. There's a lot of stuff in this world to lie about. In the digital age, where we can pull up everything you say on a news station, that man did not lie about that. He said he didn't say it. He didn't say it. They got the wrong person. It's okay. Wasn't that big deal. They should have just so stricken from the record and moved on real quick before anybody could bring up any type of procedural issues with that. And I remembered that about him. There's plenty of things to lie about. That is not something that people lie about. He didn't say it. But he wants to get into judicial philosophy and textualism, and he brings up Alexander Hamilton's Federalist 78. I will say I kind of get annoyed. I love the Federalist paper. Like I told you, I was a Federalist in law school. I have no problem with the position, but Federalist papers are not law. That's just it. I don't care who wrote it. I don't care who great grandpappy wrote it. It's not law. Alexander Hamilton, love him. That's not law. That was what that was what I'm doing now. Same as I'm doing. That was his recap and review of some stuff. We use it as legislative insights. We use it as trying to figure out what the public may have understood the plain meaning of words at the time was. That is great. But the fact of the matter, it's not law. It's not binding. It's not authority on anything. He talks about judges can't be fired by the people. I already told y'all there's a check and balance for everything. Might not be instantaneously, but believe me, everything has a check and a balance. He asked about if Biden had said something to her, or a conversation that if she had with Biden. She said she didn't have it. He moved on. Let's see. He asked about interstate commerce. He asked about, and then he gets into the child, the sentencing. She repeats the same points, which I told y'all. At first, when I heard it, I was like, hey, you got some explaining to do. Shout out to I Love Lucy. But once she explained it, it made sense. Practically, in reality, it made sense. I can't argue it. Then Senator Klobuchar, she is a Democrat from Minnesota. She talks. She opens up about the sentencing, and she says that is a nationwide downward departure. It happens. She talks about even other conservative judges have the same sentences. She brings up the Fraternal Order of Police endorsement. And she does the character rehab I was telling you guys about. She brings up a few numbers that I thought were interesting. Out of 2,000 plus senators that there have been in our nation's history, only 58 have been women. Let's see. She talks about antitrust cases. If y'all don't know, that is my bread and butter. Antitrust and big tech. I'm most interested in that, but she was just kind of using that time to just talk about some things. Then Ted Cruz talks next. Y'all know he was the loudest person in the room. That's what I remember, screaming and yelling. I think I wrote, before I even wrote a note, I said, here we go with that hollering. It bothers me. It really bothers me. Ted Cruz is intelligent. In law school, I remember we read a case that a Supreme Court case that Ted Cruz had written a brief for, or in some way had worked on, something like that. I don't know why he gets up there and does all that scream. Maybe that's just his personality. Try to be understanding. But he went to law school with Katanji Brown Jackson. They were in law review together. She was 1 year ahead of him, I think. Yeah, I think she was 1 year ahead of him, is what they said. It's just so funny that, they're probably not that, they're probably of the same age, they're contemporaries of each other, and they just looking at them, I would have never thought that they were the same, that they would be the same age to have been in the school together. I'm gonna let y'all make up in y'all mind what that means. But then he talks about, she was given a speech, and she called the woman who wrote the 1619 project, called her provocative. And Ted Cruz wants to know what she thinks of that, and she says she was just giving a speech. She doesn't really know anything about the 1619 project itself, but she was just giving a speech. And then Ted Cruz brings up the CRT, critical race theory. She explains that it's an academic theory on how race interacts with laws. It doesn't come up in her judicial review. Then he talks about critical race theory being taught at a private school that she sits on the board of. She says the board doesn't make curriculum decisions, and it is a private school. Katanji Brown Jackson said the school was founded during segregation, when 3 white Jewish families and 3 black families got together and started the private school so they can integrate and have their kids go to the same school. Let's see. Then Ted Cruz brings up these books, anti-racist baby books and kid books teaching people about racism and not being racist and stuff like that. And Katanji Brown Jackson said that her work as a judge, critical race theory doesn't come up. She don't deal with it. And then Ted Cruz goes back to the child stuff and something she wrote about in school. And she said back in the 90s, when she wrote that paper, she was writing about Megan's Law. And at the time, Megan's laws and having sex offenders register, those were newer things. That was kind of novel in that era. Y'all imagine, nowadays things move so quick digitally. Like, we'll be on one thing one week, and then the next week it's a completely different focus. But back then, getting online registries and things together in the 90s, yeah, they had registries online, but we all know how computers look back then. So at that time, it was novel. It was a little bit new. So that's what she wrote about. As an attorney, as someone who went through this in law school, yeah, that's what you do. You pick a topic that's not going to bore your professor to sleep. You pick a topic that's a little bit new, in hopes that if your professor is interested in it, they might, grade a little bit more generously. Yeah, that's what you do. So that's the topic she picked. He says it leads into a pattern, this, that, and the third, with the sentencing. Ken had the nerve to be drinking a Diet Pepper. But I'm not gonna get all of that. I'm gonna move on. What else? Then he brings on the chart of the sentencing. I don't know. I got off of him. I can't take it. All that yelling. Senator Coons speaks next. He's a Democrat from Delaware. He basically gave her the opportunity to finish up what she was saying, the Holland cruise, and then did character rehab. He mentions that this is a nationwide downward departure from the sentencing guidelines. It is, in fact, a norm. And you know something? I explained earlier about the technological reasons that we might be downwardly departing from the sentencing guidelines. But now that I'm thinking about it, another reason might be because jails, prisons are crowded. I don't know. They either need to build more or get people. I don't know, but they're running out of room to put people in. So I'm not saying that I like it, but I'm not going to say that she's just, it's ill to characterize that she's just out here saying, you get only a day and you get only a day and you get only a day. That's not what she's doing. There's a very logical explanation to what she's doing. You don't have to like it, but it makes sense. Senator Coons goes ahead and brings up one of her decisions about the border wall, and she ruled in favor of the Trump administration. And Katanji Brown Jackson said it actually wasn't about the policy of the wall. The issue was, it was an Administrative Procedures Act case. The issue was, did the agency follow proper procedure? So, and then said, that's just what it was. Senator Sass, Republican from Nebraska, he goes next. He's a very calm individual, and he is not an attorney, Senator Ben Sass, but he perhaps provided for this day 2, and when I do day 3, he did it again. He provided one of the more meaningful engagements. He said that it was very important for him to determine what her judicial philosophy is. And points out that she gives a nod to originalism and things like that. And she says that she just doesn't have one, which, if you think about it, a lot of the Supreme Court justices came from academia. They primarily spent writing theses and books, and there's nothing wrong with that. It's a dream job, believe me. If somebody's hiring to be a professor, I could just write books and stuff like that and go on sabbatical. Wonderful. There's nothing wrong with that. But when that's your job, you have time to develop more of a philosophy, more of a judicial legislative philosophy. Whereas she was a practicing defense attorney and then a judge. So her, whatever it is that she has and how she looks at the law and how she examines cases, that comes from practical experience. So I understand when she says, I don't have a judicial philosophy, I have a methodology to how I approach my, what I'm doing. So that makes sense to me. And they go through that. He said that what impressed him was that the things that she keeps saying in public matches the things that she was saying when she met with him in private. And he said, clearly, clearly she's honorable as a person. I'm not going to go through all of his, but I just will say that they had a back and forth about originalism and how she understands what originalism is, and how I think she talked about cases where an originalist and a non-originalist where two justices take originalist approaches and come to a majority and a dissent. Anyway, it was a long, I can't. I'm gonna cut it short. Then Senator Blumenthal. Um, oh wait, back to Ben Sass before I wrap up. He asked her about Roe, Roe v. Wade, and Casey. I think Casey v. Planned Parenthood, um, and how those would have been originalists and this and that. And I can't remember exactly the exchange or the response, but I remember um, when we think about fundamental rights and rights not enumerated in the Constitution, my understanding of some of these cases is that they come from a broader right. So my understanding of Roe and Casey, I think Roe legalized the getting an abortion procedure, and Casey said that you can pass limits on that in your state, but it can't be an undue burden on the woman who's seeking the procedure or the mother who's seeking the procedure. And then there was a case before Griswold v. Connecticut, older case before Roe, before Casey, that gave women the right to seek contraception if they wanted it. My understanding of those cases and how those became fundamental rights was that those were born out of the right to privacy. So my understanding is the right to privacy is a fundamental right. And if you are telling people that they can't control their reproductive freedom, then you are you are significantly diminishing the fundamental right to privacy. That was always my understanding of how we get these so-called new fundamental rights. To me, these aren't necessarily standalone rights. These are part of the bigger picture of what we think of as like life, liberty, and the pursuit of happiness. So if you take away these things, you are greatly diminishing the right to those to privacy, to pursuit of happiness. If you take away these things, you are greatly diminishing my liberty. So that's how I always understood these rights. I've never understood these just to be standalone. Oh, you have a right to this now. No, that right falls under something, something else that if we take it away, we might as well have taken away the bigger right. That's the best way I can explain it, but it's neither here nor there. And Senator Blumenthal speaks. He's a Democrat from Connecticut. He, gushes, talks about advice to young girls who now see her going through this process and might be looking up to her. He said that he wants, he said that, we think of enforcement of the criminal justice system as saving lives, but he said that, defense attorneys save lives too. He said that he had to represent for the NAACP an African American man who was on death row for sexual assault, and he said he ended up getting the guy exonerated, getting the charges cleared. Apparently, the prosecution had withheld exculpatory evidence. That means evidence that might prove the person didn't do it. That is a big no-no ethics-wise for attorneys, all attorneys. You have exculpatory evidence, you must turn that over. But he said, he got the guy off of death row and out of jail because the guy didn't do it. So he said, work as a defender also saves lives. And I thought that was an interesting way to look at that. I never thought of it that way before, but yeah. They talk about the cameras in the Supreme Court. I'm telling y'all, I don't want it. I don't want it. I don't want it. I think, I listen to Supreme Court. Y'all, I'm going to start reviewing them. I listen to Supreme Court cases live on YouTube, and it's just fine. They even put up when the justice speak, they put the who's speaking on there. I don't want cameras in there because I do feel like it's going to turn into some mess. it's gonna turn to some mess. It's a big old mess. Let's see. They have a brief exchange, Blumenthal, a brief exchange about how the Judicial Code of Ethics doesn't apply to the Supreme Court. And I remember Amy Coney Barrett was asked this, and I remember she was a little bit surprised. Um, and, they want the justices to consider implementing a judicial code of conduct for themselves. And I don't think that's wrong. I don't think that's wrong. Why it's not? He talks about tech platforms, and then after him, Josh Hawley, Republican from Missouri, he speaks. His whole thing is on these the child stuff. That's all he talks about. She explains herself repeatedly. I might type some of this up so you guys can see it, but I'm not going to go too far into that. The only thing I will say about Josh Hawley and asking about this, I think at the point where they didn't want to give credence to the fact that she had a logical way she approached this, she wasn't just giving lesser sentences just because. There was logic behind why she was giving these lesser sentences. I think that needed to be acknowledged. And I think when we got to the point where we didn't want to acknowledge that, we weren't being honest in our intellect. We were being biased, completely biased. But what I will say is I do appreciate the fact that Josh Hawley said he said this was going to be an issue up front, and he didn't wait to the last minute to bring it up on the last day. So I got to give him credit for that. I just will say that all this tough on crime, hello, somebody, Kim Porter. I just want the same energy of being tough on crime for everybody. That's all. After Josh Hawley talks, Dick Durbin, he gives some stuff he says about the downward trend. And then Katanji Brown Jackson kept repeating that, the probation officers had recommendations too. And so that, that's something she took into consideration. And I don't know. Next is Senator Hirono. I think I'm saying her name right. She's a Democrat from Hawaii. And she asked, in 2018, she started asking this. She asked the Supreme Court nominees, have they ever sexually assaulted somebody? Are they in any type of settlements involving sexual misconduct, things like that? And I remember when she asked Amy Coney Barrett this, it was a big, how could she ask that? That's not fair to ask? No. I think she needs to ask everybody this. And I like that she asked the women and the men and anybody in between that, because women have hands just like men have hands. And there's some women out here who might be feeling on people when they shouldn't be too. And yes, that's how we get to fairness and equity. Don't just not ask the question. Ask everybody the question. Do you fill up people when they don't want to be filled up or felt up? Yeah, ask. So I always look forward to her asking that question. I just feel I feel that's fair, me personally. But then she goes into witness rehab, of course. And she says that she doesn't think a judicial philosophy label is important. I think she says she thinks that's for politicians, not judges. If they want to put labels on stuff, but judges should just get in. She likes the methodology approach better. And then I kind of get off her, in the interest of time. I'm gonna move on. Then, before they go on break, Hirono brings up the probation officer pre-sentencing guidelines. And so after she's done with her questioning, her 30 minutes, Cruz says, how did she get that? Because the rest of us didn't get it. And if she has it, why don't we have it? And of course, you know what he said. He said that the Democrats getting information that we aren't getting. Now, I'm not going to lie. I would have asked too. Now, granted, he was screaming and hollering and putting on the show, but what he asked was not unreasonable, and it comes up again. So they said that they were just handed it. That they just, so Dick Durbin says, oh no, we just got it. And remember, there were some discovery issues in the Kavanaugh hearing. Okay, yeah, that didn't make it right then, and that doesn't make it right now. Do y'all have things that we don't have? So make sure I didn't skip anything. This was good. I'm messy. So Senator Kennedy says, when was this handout made available? Did everybody know that it was out there, or how were they to know that they were going to get it? So they go on a big back and forth, and this was sloppy. This did look some type of way and sloppy. So Cory Booker, he's a Democrat from New Jersey. He says, he raised his hand and said, I just confirmed with my staff that I got it 10 minutes ago, and I'm upset also. So I joined Senator Cruz. That way it could be bipartisan. I thought that was cool. Stuff like that, I don't blame them. Why are we just now getting this? Who had it? Now, it was sloppy. It was messy. And they need to have cleared that up. So, they go over that. So Ted Cruz brought it up on break. When they came back from break is when they had this big old exchange. Then Dick Durbin said he moving on. So Senator Cotton, Republican from Arkansas, he goes next. He talks about the rise in crime. Basically, y'all know how he acted. That's it. Y'all know how he acted. He said he really wouldn't let her answer, and basically she gonna be soft on crime. Democrats soft on crime. Biden want to pick people soft on crime. That was his narrative the whole time. I'm not going too much into what he had to say because that was the narrative. My thing is, though, I just want the same. We're going to be tough on everybody. I want it for everybody. Either we're going to be tough on everybody, we're going to be soft on everybody, but I like it equal. Everybody. What are J6 people at? Some of them, judges let them go on vacation. What? That's where they do that at. Apparently here. Then Cory Booker talks. He's a Democrat from New Jersey. He mentions that Ted Cruz is actually his friend. He said it a few times before. Him and Ted Cruz are friends. I think he outed Ted Cruz as being a vegan for the Amy Coney Barrett hearing. Yeah, I know Ted Cruz ain't no vegan. Well, that's what they laughed about it, but that's his friend. He did character rehab of the witness, and let her explain more of that sentencing discretion and how it came about and how it's the norm, and just really gave her opportunity to respond and discuss her faith and things like that. He didn't ask any too hard-hitting questions. So then Senator Kennedy, the Republican from Louisiana, it was his turn to talk. He goes into, judicial philosophy, non-enumerated rights, those types of things. One thing that stood out to me about Senator Kennedy, Republican from Louisiana, Judge Katanji Brown Jackson keeps saying that as a judge, she tries to stay in her lane. And this phrase apparently just tickles Senator Kennedy, and he it's like he's never heard anybody say "stay in your lane" before. And if this is the first time that he's ever heard like people talking and people saying, stay in your lane and using it, then I don't think that he's a good representation of Louisiana society. Um, I think, yeah, I'm from Louisiana, and I can go up to any type of body in all walks of life in Louisiana. And if we're talking and I say, oh, you need to stay in your lane, they're going to know what I'm talking about. And not based on color, not based on socioeconomic status or anything. That's just how most people there talk. So for him to, and he keeps bringing it up like, and stay in your lane. Like he is really tickled and fascinated about the phrase "stay in your lane." Like he's never heard it, and I just feel like that indicates that you are out of touch with something, um, you know, in some form or fashion. But whatever. Um, what else did he have to say? Um, that's not much. I do remember that to me it seemed like I think at one point I wrote that Senator Kennedy is the head gaslighter in charge. I'm gonna leave that there. Then Senator Padilla spoke. It was his birthday. I thought that was cool. Democrat from California. Um, he mainly pontificated. I think I'm using that word right. He didn't ask hard hitting questions. He talked about voting rights, and he did go on a monologue about more diversity in clerkship positions, because those clerkship positions um, often lead to being in the position of Katanji Brown Jackson, where she clerked for Judge Breyer. And he said there needs to be more diversity, um, not just African Americans, but Native Americans, Hispanic Americans. He said the clerkship opportunities aren't very diverse. So then Judge Katanji Brown Jackson shares how fulfilling and rewarding that her clerkship experience was. Um, then Senator Blackburn speaks. Now, they were going to let her, because they didn't finish. Two had to go. So after Blackburn speaks, they break for the day, and then they finish the 30-minute rounds on day 3. Yeah, they finished the 30-minute rounds on day 3. Senator Blackburn technically was supposed to be the last one to talk, but Tillis decided to change places, or Ossoff. Somebody changed places with her because she had to get, it was so important for her to go today. They went until 9 o'clock at night, pretty much. So it was a long day. But anyways, so she's the last to go for 30-minute rounds for day 2. And she talks about a particular case that was about pro-life protesters at abortion clinics, and somebody in the case called them noisy and in your face. And she says she has friends, pro-life friends, at where she lives at. She's Republican for Tennessee, and they said, well, we like her, we just don't agree with her on the issues, and does she think we're all nosy and in your face and this, that, and the third. I think for her, I wrote that she's the head Karen in charge. And I will say this: that case wasn't about who can and cannot protest. Everybody, can protest, but it's not what you're saying; it's what you're doing. So if you're protesting and you're standing right up next to me, but you're just screaming and yelling, you're not really in my face, other than you're just loud, that may be one thing. But if you're all in my personal space, That's a completely different thing. So when we're talking about protesting, I would like to know how they were protesting. I said the same thing with the riots or whatever they're calling them from 2020, I think, or whatever was going on. I said the same thing about those January 6 people. Protesting is one thing. Picketing, you do maybe need to be across the street from whatever it is, particularly if somebody is going into a clinic, whether you agree with what they're going into the clinic for or not. It's really none of your business. Um, but it's not what you're saying or what you're demonstrating for, it's what you're actually doing. Are you being disruptive to the point where you're in my personal space and disruptive? That's an issue. But, you know, they didn't go too deep into it. So that ended day two, 30-minute rounds. The next day, they had to finish the 30-minute rounds. And when they got there, I'm going to do day three, I'm going to do um, on a separate video. But when they got there, Dick Durbin opened up to talk about, um, I don't know what he wanted to talk about. But when he was giving his little opening remarks, Senator Corrin, Republican, can't remember what state right now, he said, after all of the questions, Durbin wants to editorialize and takes up all this space. Now, I remember the Amy Coney Barrett confirmation hearing, and Lindsey Graham did the same thing when he was the presiding senator. He editorialized after every um, question or whatever. Well, Corn doesn't think that that's appropriate. And then Senator Kennedy, Republican, Louisiana, he agrees. He doesn't think that was appropriate either. Now, I will say this: they both do it. Both sides do it. Okay, whatever. Grow up. You're just mad because you're not in charge. However, Dick Durbin talked slow as lasses. He just talks slow. Lindsey Graham is a little bit, more charismatic. He's a little bit more animated, but he's not yelling, not aggressive or really like that. Lindsey Graham maybe is a little bit more entertaining. So when Lindsey Graham was doing that editorializing, maybe it was a little bit more entertaining because I'm not gonna lie, Dick Durbin do talk slow. So I'm not saying that make it right. I'm just saying that is one thing to point out that if you do have to listen to some if you do have to listen to somebody editorializing, maybe you would rather listen to Lindsey Graham than Dick Durbin, but both sides do it. Okay, so then so Chuck, wait. Did they get into those documents again? Uh-uh. Okay, so then Chuck Grassley speaks. Um, and this is before we finish up the 30-minute rounds. So Chuck Grassley says, oh, he brought up the probation documents from last night and how it got there and why they didn't have it and this and that. And all I'm going to say about that is that was ignorant. I'm sorry. I just do believe that why y'all didn't have y'all stuff together? And why didn't everybody, did you post it on the bulletin board when the stuff got there? Why did some people know it was there and some people didn't know it was there? Y'all should have walked out and said, hey, just so everybody knows, these documents are here. But that was messy. Okay, so then we finish up our 30-minute rounds. We get Senator Ossoff, the Democrat from Georgia, newly elected. And he goes into the role of government, the role of judges. Um, I guess he said his district is only one of three that doesn't have a federal prosecutor's office that he's trying to get. Discusses free speech in the press. this is his first Supreme Court confirmation hearing, which, that you hear them, Feinstein say it was her 10th and it was someone else's 8th. So I thought that was cute that it was his first one. And he talks about how over time the nominees, they say less and less. They refuse to comment about things, and he says he understands why they do that, but he thinks that the Katanji Brown Jackson, she was actually a little bit more forthcoming, which I think she was too. I think she actually answered. I personally, I just think we need to. When you're a judge, you're trained to be impartial. Um, and everybody has personal opinions and positions on stuff. So I wish that the judges could be a little bit more forthcoming when they talk about, this is my personal position, but when I've taken cases or when I review cases, these are things that I'm most looking for and putting my personal aside. But hey, it's the world we live in. Um, Ossoff and Katanji Brown Jackson have an exchange about the courts, about the Fourth Amendment, um, how we have Fourth Amendment circumstances, or even in general circumstances that would not have existed at the time of the founding. And he tells Ketanji Brown Jackson to remain vigilant about issues that she might need to seek advice beyond her expertise. And he gives her two questions. He says, one, you know, um, well, they have two line of conversations. The first is he wants her to vigorously defend our the same rights we have without technology, defend them as we use technology, is the best way I could paraphrase it. And then he says, when it comes to these amici briefs. So, amicus brief, friend of the court, amicus curiae means friend of the court. They're briefs that, you know, let's say you're not a party to the lawsuit, but it involves something that might concern you, depending on how the decision goes. And so you might submit a brief to the court. A lot of times, these briefs are helpful because they become part of the factual record. What does that mean? When the parties come to court, they present a set of facts. One party presents a set of facts, the other party presents a set of facts. Then you have experts and maybe amici briefs, um, with more experts who talk about those other things. Judges don't go out and research on their own. That's not really fair. It depends on what the parties bring before them. Courts are passive. So he wants her to be mindful and to consider the fact that some of these amici briefs do come from special interest. Just be mindful of where the source of the amici brief, and if the amici brief is pushing an agenda as it relates to some of these new technological issues, which, she hopefully she should have been doing that anyway. But at the same time, like I say, everybody has an agenda. So it's very rare that there's just a completely neutral. I'm not saying there can never be, but let's be honest, everybody has an agenda, and these judges are expertly trained to sort through that and figure out, what does the law dictate in this situation. But she's perfectly capable. And then Tom Tillis, Republican from North Carolina, talks. I told y'all that he had irritated me, but these proceedings, I'll say that I think he's been um, fair and even, not doing too much, not screaming and shouting and stuff like that. But he talks about he brings up the past confirmation hearings, and I wrote down. I said, we don't want to hear about it, but you bring up things sometimes to remind people of how bad it was, and so they don't do that mess again. Because some of it was a mess. Not my fault. Don't do mess, and people, if you don't do it, people can't bring it up. Um, he also is not an attorney, in which I told y'all how he talked about that man. Oh, he's just a trial attorney, but I'm not gonna give him too much. I'm gonna let it go. I'm gonna let it go. Um, he talks about court packing and the arguments on both sides for court packing, and she, of course, that's a political decision. She's not gonna get into that. He says it's dark money on both sides. So just he said it's on both sides. He said hopefully it goes away. Um, and then he uses a lot of his time to talk about different issues. Like he says, when Donald Trump, this is Tillis is Republican from North Carolina. He said when Donald Trump wanted them to get rid of the filibuster, he signed a petition that said no, we're going to do it. Um, Along with some of his Democratic colleagues, and he said that he was disappointed that now they times have changed. I guess he said he didn't want a court pack either. He didn't want to do it for his side or the other side. Um, you know, court packing. I'll explain that when I do the 20-minute rounds because I think it comes up again. He brings up he brings up the protesters that Blackburn had talked about the day before, and Katanji Brown Jackson clarifies that it wasn't about, it was viewpoint neutral. It wasn't about the type of speech. This was about, what do they call them? Buffer zones. You know, you need to be this far away. She said that at the time that she took this particular case, these buffer zones were still, the law is still hammering these out, with how they touch up against free speech. But my understanding is that you can always limit the time, the manner, and the location to a certain extent. The government can. And then if you own private property, you can tell anybody to get off your private property. And if you're the government, you can limit the time, manner, and location of where people can demonstrate. And then if you're private property, let me I'm gonna move on. I just feel like if you're private property and you also live in a state that's a stand your ground state, then it should be understood by all parties what it is. And what it is that you need to get off of private property. No matter why I tell you to get off of private property, you need to get up off it. Whether you got a picket, a sign or not, a whistle or not, get off it. Um, but whatever. And I wrote down again, it's not about bad speech, good speech, bad protest, good protest. It's about acceptable and unacceptable behavior. And there is behavior that no matter what, there's behavior that's unacceptable. I thought he gave a good exchange. So then, that was the end of the 30-minute rounds. See, I knew this was going to get kind of long. So that was my recap and review of day 2, 30-minute question rounds for the confirmation hearing of Judge Katanji Brown Jackson for considering to be a Supreme Court Justice. I'll do a separate video for the 20-minute rounds. Hopefully it will not be as long. Thank you guys. I say you guys like it's a lot of people watching, probably like 2 people. One of them might be family. Again, I do these recap and reviews not so that you don't have to watch, but I know that not everybody has time to sit and watch 13 hours of 30-minute rounds of questioning. But, get interested. Maybe peek in on them sometime. Look them up. Fact check me. Um, you know, That's it. Until next video, bye-bye.